Larry, we've got a special late night edition tonight. Very good to see you. You're looking well. How you feeling tonight?
Feeling good, Jason. In a humorous mood, I guess, if you can call it that.
That's good. A
I'm
lot of
looking at
people,
your
I
meme
think,
of Katanji
yeah.
Jackson. That's one of the greatest memes of all time. I think it's great,
Well, thank you. I appreciate that. A lot of people have questions, I think, Larry, about this SCOTUS decision about nationwide injunctions. You know, some people were saying, hey, this is the end of lawfare. Other people are talking about some detailed aspects about how class action suits will be employed now. I thought it would be a good opportunity for you and I to discuss that a little bit. We're going to start here. And of course, people know we've got our sponsor exclusive segment of the show. People can get on to freedomwatchusa.org and sponsor the work that you're doing there. It's very important work. And we're not seeing a lot of this kind of stuff coming out of the Department of Justice even now, but people can go over to freedomwatchusa.org. We're going to talk about some of the cases that you're working on there. But tell us a little bit, what is it going on really with the injunctions in this SCOTUS ruling?
I don't begrudge President Trump. I think he's doing a great job. I support him. He's a salesman. I'm a salesman. I'm a trial lawyer. You have to make a sale to the judge and you have to make a sale to the jury. But a certain number of things are being a little bit oversold these days. We're not going to get into Iran on this show. I think that's being oversold too, that there's going to be peace with these satanic creatures that occupy Tehran. But moving on from that, the decision by Amy Coney Barrett is being oversold. It is a step in the right direction, and it's a very good decision. And what she found is that injunctive relief, that's called equitable relief, is limited to the parties in front of the court. And in the district or the circuit, the district is the lower federal court, or the circuit, which is the appellate court, from which it emanates, and particularly the circuit. But there's a loophole. In addition to that finding, she leaves a little loophole that if there's a class action, which entails more than the people that are in front of you in that court, that it could have broader application in other parts of the country. But here's the problem, is that once you have a court decision, particularly at the appellate level, other courts look at it for guidance and or precedent, in their cases. And consequently, it will have an effect throughout the United States. And of course, we know the left files cases in places where they believe they're going to get a favorable judge, and they do. Not just the wheel of fortune, it's supposed to be done randomly, but they'll file them in Boston, Massachusetts, which is leftist. They'll file it in Seattle, in Portland, in Chicago,
DC,
in New York, and other places. And these judges will stretch the limits because they have what they believe is life tenure. And Jason, they don't have life tenure. They serve for good behavior in the Constitution. They do whatever they want. And the biggest problem here, which is still untouched, is that federal judges, have been given immunity by the Supreme Court that gave it to themselves. There is no immunity in our Constitution. There is a passing reference to the common law, to be applied. But it's also interesting when you read Coney Barrett's decision, she goes back and tries to apply the common law under the king. And of course, that suits, this ruling that equitable relief is limited to the parties in front of the court. That's what they do with immunity. They go back there, and because King George III gave immunity to his judges so they could rubber stamp his illegal edicts, they say, okay, we got it as well. And then it goes further than that. It goes to Bar Disciplinary Council, who think they can do whatever they want in the District of Columbia and New York in particular, where they're leftist and trying to disbar conservative lawyers. It goes into the government, where government officials claim immunity. And this is something which has paralyzed our legal system and gives, when we're getting back to judges, the carte blanche, so to speak, in French, to do whatever they want. And they don't care, because even if they're wrong, it goes up on appeal, it delays things, it increases the cost of litigation.
Right.
And we still have a legal system which is, for the most part, corrupt from the top to the bottom on the federal level. And that's why we have formed, and you're a member of this as well, Jason, because you're a real student of the law. You've become that over the last many years and very knowledgeable, and you are doing work that is changing the legal system. That we have a Department of Judicial and Legal Accountability at Freedom Watch, which are going to make recommendations, to actually pass legislation. Hopefully, we're working with Nancy Mace on Capitol Hill. She's very courageous, and others, prominent people, Bob Barr, Alan Keyes, former UN ambassador, others. But we're also going to be bringing citizens' grand juries to hold these judges accountable, have them tried, have them convicted, and have them do a little time, which we trust will occur with the help of law enforcement, because they are outlaws, and they've acted like outlaws. And the biggest outlaw here is Ketanji Brown Jackson, who's a DEI appointee. Biden said, I want a black woman. Well, he could have done better than that. I mean, there are intelligent black women in this country, but just so happens she's part of that Washington, D.C. establishment. When I appeared in front of her when she was only a district court judge, a lower court judge, she asked me, I don't really know what the Freedom of Information Act is about much, Mr. Klayman. Can you explain it to me? I mean, she is dumber than a rock, okay?
That's amazing that a judge would admit that. I mean, that's like a doctor, like looking up something in the book when you go to, it's like, wait a minute.
I once had Burl Howe, who was the chief judge of the district court in District of Columbia as well. It was funny. I think I told you the story before. I was kind of spaced out at the time. I was breaking up with a girlfriend at the time. I was single. And I actually, I had a conference call on it with the phone on her, with my phone, and I called her honey, right? And she liked it. She actually liked it.
She said, hey, what are you doing after the hearing?
And then she said to me, Mr. Klayman, I think you know more about this than I do. Give me some guidance. Right?
Wow. Unbelievable.
But, yeah, she's a real political hack. But you know what? From a personal level, she's a nice person. She has actually complimented me in court in the past. But, she is a leftist hack. And we can get into that later about what she's doing with regard to these law firms that were sanctioned by Trump and others. But this is the problem that we have. Coney Barrett literally humiliated Ketanji Brown Jackson, basically called her a clown, basically said she never read the law.
But didn't 5 other justices kind of also agree? They didn't reprimand her for saying that.
No, they did not, because she doesn't care. She's up there. She's there for what she considers to be lifetime tenure. She's having a great old time. She's speaking, giving speaking engagements, engaging in politics, which is against the Judicial Code of Conduct. She's inserting herself in that. They all have. Ginsburg used to do that as well. The left tends to do that on the court. But she's an absolute disgrace. And frankly, with regard to the other justices, I mean, they're not pure either, frankly. And Coney Barrett's made a number of bad decisions. She's leaned left in recent years. But this particular decision that she made was a really good decision. She was correct. She wrote for the majority 6-3. Of course, it broke down against conservative leftist lines as usual. And it advances the ball, but it doesn't advance it as much as they're selling it right now, whether it's President Trump or whether it's Gandhi, both of whom I like and support, and I think they're doing a great job.
But I think also a lot of people on the news, Larry, have kind of misconstrued it. I've heard people on Fox News, Jesse Waters was like, oh, that's the end of lawfare. And I was like, what the hell are you talking about, Jesse Waters? Not at all.
Yeah, Jesse's very bright. I think he's talented, okay? But they've been told at Fox to be the ultra cheerleader of Trump. They were in the doghouse for a long time. They've got a market. It is embarrassing to watch Fox as to how much they become cheerleaders. They trip over each other. And the president deserves so much credit, but it becomes ridiculous watching the people on Fox get down on their knees and committing, excuse the French, oral sex.
Now, Larry, along the lines of what you were saying about judges and life tenure, I don't know if you had a chance to see any of this, but a Trump nominee for the Third Circuit Appellate Court is this guy, Emil Bove. Now, I have a lot of questions about this guy, but he was in the Senate. He's quite skilled at speaking, I would say, and controlling his temperament. But even the senators kept referring to, before we give someone a life appointment. And I was thinking, man, why are these guys talking about life appointments? There's nothing in the Constitution that grants a life appointment. So it's not just the judges. Like, everybody's been brainwashed on this.
Well, that's right. And we've gone over this in another show, but let's do it again in this context. We need a better way of appointing judges and policing judges. That's why I founded Judicial Watch in 1994 on July 29th, coming up right now. And the fact is they get on the bench, generally speaking, through political contributions, legalized bribery, and sometimes out-and-out bribery. We don't have the best and the brightest. We've got a Cadillac of a legal system, but we've got drunken drivers at the wheel. And this is why
I like that.
Yeah, this is why we've got what we've got, And so I think, and I proposed this when I ran for the Senate, I came up with the concept before, it's for, studied by our group, by the Department of Judicial and Legal Accountability, to come up with something even better in that and other areas of our legal system. But number one, judges should have to go and get a master's degree, like tax lawyers do, by and large, an LLM, in how to be a judge, how to comport yourself, how to act. You've been in front of a lot of crazy judges and corrupt judges, Jason. You know what I'm talking about. They don't care whether they're right or wrong. They're going to shove it up your you-know-what because they feel like it. And then, excuse the analogy.
No, they're very calculating. I think it's beyond just not caring what they do. They are calculating, and they are working to achieve not just political ends, but corrupt ends.
Well, I've dealt with it too. That's what caused me to start Judicial Watch. You can read my book, Whores and Wine, How I Came to Fight the Revolution. It was a Judge William Keller in LA, that I tangled with. And I said, I've had it. I'm starting a group. I'm going to call it Judicial Watch, to watch judges and to police them and the other two branches of government, using the judges to do it. Secondly, they should be chosen, or at least recommended for appointment, by neutral panels, okay, free from political campaign contributions. Third, and this is most important, 2 4-year terms, make it 5-year terms, renewable for good behavior. In other words, don't make it lifetime tenure, and that comports with the Constitution. You would not need a constitutional amendment for that. That exists right now. Fourth, require them, they're well paid enough, generally speaking, if necessary, give them a little more, make them buy malpractice insurance, like lawyers do. If they make a reckless or intentionally wrong decision, don't force a litigant, of average means to have to appeal it, arbitrate it to get a just solution, and have those judges insured. And last but not least, psychological testing, because frankly, many of them are simply crazy. I mean, they're power hungry. The federal bench, they are power hungry because they're not accountable. When I go into state court in Florida, whether I agree with the judge or not, 99.9% of the time they're respectful to the lawyers and they're respectful to you.
But
federal
not in district court.
With a large percentage of judges insult you, they put you down, they'll storm off the bench. Just a few weeks ago, this moronic judge, Reggie Walton, another DEI appointee of the U.S. District Court for the District of Columbia, literally stormed off the bench. When I asked him the basis of his ruling, he couldn't come up with one. Instead, he just left. Okay. And, that's up on appeal right now. It was a case where I'm challenging the D.C. Bar disciplinary apparatus for their illegal, unethical behavior. But this is something which is a serious problem. And this guy is not terribly bright. He's arrogant. He won't admit when he's wrong. He is polite, I will say that. Okay. He is polite in his own bizarre way. But even a leftist D.C. circuit overturned him in a case where I brought against the D.C. Bar disciplinary apparatus last year, and they severely criticized him for his conduct. And he did it again, in a case just a few weeks ago. So this is what you're up against. And then they hide in their chambers. They never come out. Okay, you don't know what the basis is of their decision making. And at least in state court in Florida, you get a hearing. You get to confront the judge. And Florida's not perfect either, believe me, but it's so far superior to the federal system. It would make your head spin, the difference
Yeah.
between it.
Now, Larry, there was another manipulation along the lines of what we're discussing, how this SCOTUS decision doesn't come anywhere near ending lawfare. Lawfare is such a complicated thing that people, I think, are just beginning to learn about. One of the biggest practitioners of lawfare is Norm Eisen, and he's got a cadre of maniacs who work with him, including this guy, Mark Zaid, who brought this legal action against the executive office of the President of the United States and his cabinet and a host of other agencies after I dismantled Signalgate, which was basically ended about 2 weeks ago. So there was just a ruling in this thing today. There was a hearing earlier this week or end of last week, and I have had a motion seeking leave to file as an amicus in this case for a long, long time. There's a lot of amici in this case, Larry, and the thing that's weird is the judge keeps filing mine as this unique, he's invented this, actually Boasberg invented this, request for leave to file review. There is no rule, there is no local rule, there's nothing in the federal rules of procedure that allow this, but they say Jason Goodman's motion, that's got to be, specially reviewed, they say, because I'm not a party to the case. But it's overwhelmingly the situation that people filing amicus curiae briefs are usually not parties to the case. So finally today, the motion for leave to file as an amicus was granted. And so I guess they're going to put it on the docket eventually. Maybe this is it. Let's see if they have it on there. Okay, yeah, they've put it on there. It wasn't there this morning, but now they've finally let it in after this big public hearing is over. Mine is the only amicus brief that opposes what the plaintiff has presented and points out the various ways in which nonprofit 501c3s and 501c4s are being abused in this case. So you can see this was received May 26th, not entered until July 1st. The rest of the briefs from other amici were entered right away. This is viewpoint discrimination, as you pointed out to us several weeks ago, Larry.
It is, and you're being discriminated against, for sure. You're not one of the muckety-mucks of Washington, D.C. I've gone through this my entire career. I started out as a Justice Department attorney. I went to a small boutique international trade law firm. I started my own law firm in 1983, and I started Judicial Watch in 1994 and Freedom Watch in 2003 after I ran to the U.S. Senate in Florida. I've never been a big firm lawyer in Washington, although they did try to buy my practice at one time, and I told them to go, excuse the French, F off. I remember
But isn't that probably, wait, stay on that for a second, Larry. Isn't that probably because they said, hey, this guy's bringing cases that we don't want people to bring. Let's buy the practice and then we can control it.
No, it was money at that time. I was doing international trade. I was very successful at it. And the story is when I graduated from Emory Law School, I would go up to Washington, D.C. That was 1977. And they would say, oh, you didn't go to Harvard or Yale, we'll keep your resume under advisement. Okay, so years later, when I was successful, these same law firms came to me. We want to buy your practice because they wanted the accounts receivable. They say, I basically told them to F off. But I've been up against these big firms my whole life. I have little to no respect for them. The best lawyers leave. They start their own law firms like I did, boutique law firms. And this is what you're up against, but the judges roll over to them. They give them undue deference. You can see what's happening. Trump sanctioned, and ironically, the law that these judges are making is good for you and me because they're affirming viewpoint discrimination. But Trump sanctioned Sussman Godfrey. He sanctioned Perkins Coie, which frankly should be put out of business, in my opinion. They laundered the money that caused the Russian collusion investigation. He sanctioned, I think, Wilmer Hale, and he sanctioned Skadden Arps or
Jenner Block.
Jenner Block.
That's what this
Paul
that's what
Weiss.
this whole Mark Zaid
Yeah,
case is about, is that
yeah,
he's saying it's a First Amendment violation, and I'm saying this is ridiculous. The
yeah.
executive branch has the sole and exclusive right to determine who has access to
Yeah.
classified information clearances, and these guys are trying to set legal precedent that allows the judges to decide who can access
Right.
classified information. It's a gross overreach.
The point I was making, they bend over backwards to these big law firms and the Washington establishment interests, of which you're not one. Okay. So they look down on you. Okay. And there's no basis to do that. You're much more worthy than these big law firms and vested Washington interests. And I've been up against it my whole life, so I know what you're talking about. You know, just as a little side story, Richard Nixon, who, you know, in retrospect, despite Watergate, comes out as one of our best presidents in modern history. At least he understood international relations, if nothing else. He hated these people. He could have gone to any Ivy League school, could have gone to Harvard, could have gone to Yale. He said, no, I'm not going to become an effete snob from the Northeast. And he went to Duke University, which was just becoming a great university at that time, particularly in law. And so he knew what it was about in Washington, D.C. And, you're not treated equally with the vested interests.
No, it's ridiculous. I think this is the brief where I said that it was so they're talking about, Mark Zaid is upset that he lost his classified information status. And I'm basically saying that the notion that this or any court could assert jurisdiction over the president's core command functions is an ultra vires fever dream, an affront to the Constitution, an attack on the separation of powers, and a naked effort to undermine the authority of the office of the President of the United States. That's really the danger, isn't it, Larry? It's not just because they're doing this to get at Trump, but once it's done, it affects every president in the future, and it can't be undone. It's changing the nature of our republic. That's what I don't like about it.
Absolutely. And then the doctrines of stare decisis, that you have to follow, precedent. Justice Thomas says, I don't care about precedent. If it's wrong, I'm going to change it. I like his attitude on that.
Yeah, that's good.
And I remember Judge Stanley Sporkin, who I gave an award to at Freedom Watch. I got to know him very well, a great man, great judge. He wasn't kowtowed by any prior precedent, I remember. But they're changing the nature of legal practice. And the Washington, D.C. legal establishment is a cesspool. It's corrupt to the core. They're basically bag carriers. That's what they are. And I have little to no respect for these big law firms in Washington, D.C.
Sporkin died in 2020, it looks like.
He did. Very sad. He actually was a very good friend of mine. We became good friends.
Well, we have a lot more to discuss, Larry. You've got cases. We're going to talk a little bit about Laura Loomer's case against Bill Maher and HBO. We've only got about 2 minutes left here before we make our way over to the sponsor exclusive segment. People are going to be able to watch that. People should definitely get onto freedomwatchusa.org, and people who are sponsoring Crowdsource the Truth are going to be able to watch that sponsor exclusive segment. Can you give us a little taste of what's going on with the Bill Maher case?
Oh, it's really interesting that they are so frightened that any discovery will come out to expose them, to expose just how low class, disgusting, and sexist and misogynist Bill Maher is. That fought tooth and nail.
People don't know that already?
Laura was used as a tool to get to Trump, at the height of the presidential election.
Oh, right, because he had dinner with him, right?
Well, I'm talking about why she was defamed, and we can talk about that, in the next segment in greater detail. She was defamed by Maher, who supported Kamala Harris. He's given money to Kamala Harris. You can check out, FEC records, Federal Election Commission records. She was accused, and I'll use the exact words, of fucking the president of the United States behind the back of Melania Trump, thereby committing adultery. And then he put down Trump and Melania Trump saying, well, obviously they don't have sex, blah, blah, blah. And this was to harm Trump, but they used Laura to do it, and they really harmed her. And at that time, she was being considered for a White House job, and they made her radioactive. Not in great financial shape as a result. And so we brought a case, and occasionally we say what's going on in that case. But we wanted to have the deposition of Bill Maher released so the media could see it, and we wanted even to have her deposition released, and the magistrate judge ruled against that. Now we've got that up on appeal to the presiding judge, and I'm confident that he'll let that come out because, they browbeat her at that deposition. These female lawyers that, pay to play, in effect.
Yeah.
Imagine female lawyers destroying another woman who was accused of that. It's disgusting. This law firm, Davis Wright Tremaine, I've been up against them many times. I can't stand them. They're one of the most dishonest law firms I've ever had to deal with. And they're anti-Trump, and they advertise that. They did advertise that on their website.
Yeah, I mean, one of the most dishonest. It's like, how does one get more dishonest than the next? They're all absolutely horrendous. We're also going to share some more information about my legal battles with Nina Jankowicz, who I'm finally able to speak about after 2 years of what I think is an unconstitutional gag order brought about by lies and deception, also from female attorneys. I think this is happening, Larry, because I've exposed evidence that is criminally actionable. I haven't proven the allegations of the, crimes that I've accused her of. I'm just citing evidence that I've seen in the public domain that I think establishes that she's committed these crimes. It's different than other people who are saying she's crazy and she's singing Harry Potter songs. I'm talking about public domain facts, self-authenticating evidence that if someone were to act on it, I believe could get her indicted on felonies. So we'll talk about that some more.
I might add, if people want to read about Laura's case, go to Larry Klayman with a K, LarryKlayman.com. And frankly, she raises money to pay the costs. I do too as well, because it's very expensive. Even one deposition can cost $10,000 to $15,000. We've deposed HBO corporate rep. We want to take the deposition. We can talk about that of the CEO of HBO. I can tell you why we want to do that.
Yeah,
and we took
that'll be good to discuss.
And it's very expensive. So if you go to LarryKlayman.com and contribute to her costs on PayPal, that would be great.
There you go. All right, Larry, we'll be back in less than 5 minutes. Stay with us, everybody. There's still a lot to discuss, exciting legal cases, and we'll be right back.